Good evening and welcome to our webinar on discrimination based on disability. My name is Ali Gemma, CDC Program Director, and I will be your moderator for the webinar. This webinar is being provided as part of the Tourette Health and Education Program, a program of the Tourette Association of America in partnership with the CDC. During the webinar, we will be very happy to hear from you and include your voice in the conversation. You can ask questions or share comments using the question panel on the right side of your GoToWebinar player at any time. We will collect your questions and address them during the Q&A session at the end of the presentation. Additionally, you'll note that we have a handout of the slides that you can download from your control panel and will be discussed in the presentation. I want to mention that funding for this webinar was made possible by our cooperative agreement with the U.S. Centers for Disease Control and Prevention. The views expressed by speakers and moderators do not necessarily reflect the official policies of the Department of Health and Human Services, nor does the mention of trade names, commercial practices, or organizations imply endorsement by the U.S. government. It is with great pleasure to introduce you to our speaker this evening, John Herrion. Mr. Herrion is Director of Disability Rights for the New York State Division of Human Rights. He is an attorney with extensive experience in disability rights. Mr. Herrion has published numerous articles and has lectured extensively, including continuing legal education programs for attorneys on the rights of persons with disabilities. He is a past chair and secretary of the New York City Bar Association's Committee on Legal Issues Affecting Persons with Disabilities. And Mr. Herrion holds a law degree from Pace University School of Law and a Bachelor of Arts from Manhattan College. So now, without further ado, I'm going to hand it over to John. And John, please go ahead with your presentation.
Hi everybody. Thank you very much for that introduction, and to the Tourette Association of America for this opportunity to be with you this evening and to speak a little bit about the protections that are afforded under the New York State human rights law to people with disabilities, people who are living with Tourette syndrome, people with a variety of mental health issues, and how the New York State Division of Human Rights enforces those protections. I got my introduction to the Long Island Tourette Syndrome Association through my summer intern this summer, Eric Zwilling, and had the opportunity to be with them out at Hillside Hospital in Glen Oaks in August, and we did a presentation there. And it was well received, and this is kind of an example of the continuing partnership we're hoping to continue with in terms of educating people who are living with Tourette's, educating their people to take care of them or advocate on their behalf, to understand that there's a civil rights component that exists when we're talking about the overall living with Tourette syndrome, in terms of there are protections that exist under the state human rights law to keep people free from discrimination based upon the fact that they live with Tourette syndrome, and that extends to employment, housing providers, and owners of places of public accommodation. So those are the areas I'm going to touch upon tonight. I'm going to talk a little bit about the Division of Human Rights and how it enforces that law, and then talk specifically to the provisions of the law that protect people with disabilities. The division, we have 12 offices around the state of New York. We enforce the New York State Human Rights Law, which prohibits discrimination on a wide variety of bases: color, religion, sexual orientation, age, disability, which is what I'm going to focus on tonight. We enforce that law by investigating complaints. It's very easy to file a complaint with our agency. The final slide in my presentation includes my contact information. The Tourette Association of America has that contact information as well, so you can feel free to contact me or go to the division's website. You can download our complaint form right from the website. You can fill it out, have it notarized, and mail it in. You can contact one of our offices directly, come in for an appointment. We're very user-friendly in terms of getting complaints filed. And then investigating those complaints is what our obligation is. So once we get a complaint filed with our agency, we then assign it to an investigator. And the investigator is going to interview the complainant, interview the respondent, look at documents, speak to witnesses. There's a wide degree of authority the investigator has with regard to gathering information to make a determination as to whether or not there's probable cause to credit the allegations of the complainant. And if there is, it goes in front of an administrative law judge. So there's a hearing on the issue, and that administrative law judge makes an order based upon the testimony and the evidence that was before him or her, and that order can include remedying the discrimination if indeed that was found. Ensuring that somebody who's living with Tourette's gets the job they applied for if they were denied that opportunity because of the fact that they were living with Tourette's syndrome, or somebody who was denied a housing opportunity is given that opportunity to move into that apartment or that home, and that denial is reversed. As well as compensable damages. Monetary damages are also available for persons who have been wrongfully discriminated against to compensate them for any compensable injuries or any pain and suffering they've endured because of that discrimination. So again, we're user-friendly. We investigate the complaints that come before us, and we seek to remedy the discrimination that people may encounter. I mentioned on this slide we got over 6,000 complaints alleging discrimination last year. A third of those complaints allege discrimination on disability. So disability and race are the 1 and 1A when it comes to the volume of complaints that we see here at the agency. We have a lot of work in this area. We get a lot of complaints in this area around discrimination based on disability. I want to cover who, or talk about who is covered. How do we define somebody who is protected by the law because they're considered disabled? And we have a very generous definition here that talks about physical, mental, or medical impairments that result from any number of conditions that prevent the exercise of a normal bodily function. Very generous definition. We don't tend to get very hung up here on how disabled are you in order to be protected by the law. Two other prongs that we cover in terms of being defined as an individual with a disability is a record of an impairment, or if you're regarded by others as being impaired. That first bullet there, the record of an impairment, is an important one for people living with Tourette's, people living with other type of mental health disabilities or disabilities that may not be otherwise visible to people. Somebody may be perfectly healthy and living a life that they don't consider themselves to be disabled. They're working, they're not having issues, and yet they have a record. They were diagnosed with Tourette syndrome at some point in their life, and there's a disclosure made. And a lot of times in the course of our investigation, we're looking to find out what did the employer or the housing provider know when they made a decision to deny service or deny employment. And regardless of whether somebody's manifesting the condition of Tourette or is not, but has a record of that impairment, they're going to be covered as a person with a disability. So again, it's a very generous definition that we have. I oftentimes try to compare it to the Americans with Disabilities Act definition, which the Americans with Disabilities Act is a premier federal piece of legislation that protects people with disabilities across the country. But the definition of disability under the ADA requires a substantial limitation of one or more major life activities for an individual to be protected under the law. If you look back at our definition under the state human rights law, there's no mention of substantial, how as a qualifier as to how substantial the disability. There's no mention of major life activities. Again, we don't get hung up here on the agency as to how disabled are you. We are looking, our investigations are focused on whether or not discrimination took place, and we think that's where the focus should be. Very few cases at our agency get dismissed because the individual is not considered covered as an individual with a disability under our law. I want to touch on employment. We get 85% of our complaints alleging discrimination against employers. So it is far and away the #1 area statistically that we get complaints. Looking at the complaints a little deeper, somewhere in the neighborhood of 10 to 15% of those complaints are by complainants who are alleging to have mental health disabilities. So that's how the numbers play out. We cover pretty small employers here throughout the state. If you have 4 or more employees, you're going to be covered by the human rights law. Again, another distinction with the ADA, which applies to 15 or more employees. Again, the New York State human rights law is very generous in its coverage of people with disabilities and coverage of the employers who are employing them. One of the things we look at when we get complaints alleging discrimination in the employment field is, certainly is the person disabled, which we already covered in terms of the generosity of the definition, but the person also has to be qualified to do the job. The law is not intended to tilt the playing field completely in one direction towards an individual with disability. It's designed to level the playing field. So part of the investigation, a big part of the investigation, is ensuring that the person with a disability, the person who's living with Tourette syndrome, is qualified to do the job. Looking at their job credentials, their resume, etc., is all part of the investigation. You may have an employer who hired a better qualified individual for reasons that were not discriminatory. So we need to make sure that when we're looking at these cases, this part of the definition is just as important, that they have the requisite job qualifications to be able to satisfactorily perform the essential functions of the job. And we're going to talk about reasonable accommodation in a little bit. So essential functions is a very important phrase in our law. Our investigators often look at written job descriptions. There's a big deference to employers. Employers know what functions they need to get done in order to get their business to be taken care of. So the employer's judgment as to which functions are essential is used to determine whether or not a function is essential or not. Looking at how often a function is performed and what the consequences would be to the employer if that essential function was not being performed. Again, this all goes to what is the job asking of the employee? Is the employee qualified to do that job? And if we have that covered, we can then start to look at the reasons why the complainant is alleging discrimination. And that's what we want to move on to. And when we're talking about discrimination, we're talking about pretty straightforward: a refusal to hire or interview or promote on account of disability. Certainly termination on account of disability is there. And then any kind of diminishment of the compensation or the conditions of employment, refusing training opportunities or promotional opportunities. This provision can be a bit of a catch-all, that it just doesn't have to raise itself to I was fired or I didn't get the job. It could be I was treated differently while I had the job, treated in a way that diminished my employment with this employer because of the fact that I live with Tourette syndrome or because of the fact that I have a disability. And it's that phrase that we focus on here at the agency. There has to be a connection, a nexus between what the bad thing the employer did and the fact that it was because of the individual's disability. Employers, New York State is an employment at will state. Employers can fire employees at will so long as it's lawful and not discriminatory and not because somebody has Tourette syndrome or some other type of disability. Big area that we cover, and I'm going to talk about a little bit more in depth, is the refusal to reasonably accommodate the known disability of a qualified employee or prospective employee. And we're going to talk about reasonable accommodation in a moment. Another biggie is inquiries. Employers are prohibited from inquiring about an employee's or job applicant's disability unless there's been a request for reasonable accommodation. So job applications. When I do this presentation with different advocacy groups around the state, I always recommend them to let us know if somebody is filling out a job application and there are inquiries on that are unrelated to job skills, ability to get the job done, past experience, past education. questions that are designed to elicit information about somebody's physical or mental or medical condition, those types of inquiries are prohibited under the law. Sometimes they're subtle, sometimes they're not so subtle. They could be, list any medications you're taking or any type of past family history of psychiatric or mental illness. Those questions are prohibited under the New York State human rights law. And if that job application is getting in one person's hand, the likelihood is getting in a lot of different individuals' hands. So we want to know about those kind of applications here at the agency. So again, we can remedy those kinds of wrongs and ensure that people who are living with Tourette's or other types of disabilities are not being vetted right at the beginning by having a box or being asked a question that's otherwise prohibited by law and that has nothing to do with their qualifications with regard to getting a job. So before I get to this slide, I'm going to skip ahead a slide here and talk about what the statute says with regard to reasonable accommodation. So it says it shall be an unlawful discriminatory practice for an employer to refuse to provide a reasonable accommodation to the known disabilities of an employee or prospective employee in connection with a job or occupation sought. So down a little bit. It says it shall be unlawful for an employer to refuse to provide a reasonable accommodation. So in order for there to be a refusal, what does there need to be? A request. And a lot of times complaints here at the agency get dismissed because there's no evidence that the complainant, the employee with a disability, ever asked for an accommodation or ever disclosed that they had a condition and that they needed an accommodation to continue to be able to do their job. Oftentimes the scenario is that the employer is having performance issues with the employee and brings the employee in and says, listen, we're having some problems with your production or your showing up on time or any of the above, and you're being put on notice here. You have 30 days to improve. If not, we're going to have to meet again and take whatever action we think is appropriate. And the 30 days comes and goes. There's no improvement. And the employer says, look, we met 30 days ago. We put you on notice as to these problems. We haven't seen any improvement. We're going to have to let you go. Courts there have said it's too late to raise your hand and say, I have a disability and need an accommodation. The law is not designed to make employers mind readers. And again, if somebody's not manifesting tics or other types of conditions associated with Tourette syndrome, the employer may indeed not know that there's an issue there. And that certainly goes with the whole host of other types of mental health issues that are not otherwise physically noticeable by an employer. The earlier slide says it's unlawful for a refusal to reasonably accommodate the known disability of the employee. So there has to be some type of disclosure made to the employer. Now remember, we said the definition of disability under the state human rights law is generous. It doesn't mean I have to disclose my diagnosis. It can mean I have these are the symptoms of my impairment, or I have to take these medications for my impairment and they cause me to be not so alert at 9 a.m., so I'd like to work at 10 a.m., start work at 10 a.m. instead, and instead of my 9 to 5 shift, I'd like it to be a 10 to 6 shift. That's a type of reasonable accommodation that's contemplated by the law. You'll see at the very end of this bullet here, it says, provided, however, that such actions do not impose an undue hardship on the business. So we're always balancing what are the costs of the reasonable accommodation. Maybe if it's providing an accessible work site, or acquiring or modifying equipment, purchasing software, different types of support services that are available for people with disabilities, doing job restructuring or modifying work schedules. Those are all examples of reasonable accommodations, and the word is reasonable. So we're balancing that against whether or not the accommodation would cause an undue hardship. So my example of 9 to 5 versus 10 to 6 certainly seems reasonable on its face, but let's say that that individual is doing patient intake work and all of the patients arrive at the clinic at 9 a.m. and that's an essential function of that individual's job. It may create an undue hardship on the employer to allow that individual to come in at 10 a.m. instead. So we take these very much so on a case-by-case basis. There's no, bright letter definition of what makes an accommodation reasonable or unreasonable. We are typically looking at the resources of the employer versus what is the cost of the employee. And the regulations spell out certain things that are not to be considered reasonable accommodation, including the provision of personal work-related aids such as wheelchairs or hearing aids. We sometimes see these, it looks like the complainant really would like to create a unique position that's really only tailored to their qualifications or abilities, and that's not what the law is designed to do either. The law, reasonable accommodation is there in the law to help you get the job done that exists, not one that you'd like to make up for yourself. Undue hardship, so we talked about this. The factors that are taken into consideration can be the size of the business and its budget. We're certainly looking to connect the dots. There's an impairment, there is a barrier that the impairment causes or something in the workplace causes that is an obstacle to getting the job done, and there's an accommodation that removes that barrier or obstacle, the disability. We want to make sure that the benefits provided by the accommodation remove that impediment to performance that are caused by the disability. And we talked about hardships and costs. So the regulations in this area, this disclosure of a condition, boss, look, I was diagnosed with, we're not even getting to the diagnosis. These are the symptoms I have. I'm going to need to adjust my work schedule. I'm going to need some type of time to take medication. I may need to restructure my job responsibilities a little bit in a way that I do those responsibilities. I don't eliminate them, but that I do them. It requires an interactive process between the employee and the employer. So there are obligations on both sides to interact and hopefully resolve this issue without having to file a complaint with the agency. So there are obligations on the employer. It's always smart whenever I do these presentations for employers. I try to encourage them to have policies in place that they share with their employees to understand what's involved with requesting a reasonable accommodation, who to go to, what the process is like, how it's going to unfold, and to really eliminate a lot of the anxiety and a lot of the exposure to liability that employers may have in this area. We get a lot of complaints here at the agency where an employee goes to their immediate supervisor and asks for an accommodation, and that supervisor doesn't know anything about the New York State human rights law or anything about Tourette syndrome or anything about reasonable accommodation, and they deny it. If I let you come in at 10 a.m., I'm going to have to let everybody else come in at 10 a.m., and then a complaint gets filed. So, that employer, it would have been much more prudent for that employer to avoid a complaint, avoid having to pay money for lawyers to defend the complaint or to be answerable for the complaint, to have had a policy in place to have somebody go to an HR manager who hopefully is versed in this area of the law and should be, and understand their obligations under the law to provide reasonable accommodation. Employers have the duty to move forward once the request has been made. We get a lot of complaints here at the agency where the employer has been sitting on the request for an undue amount of time, and the employee feels they're being ignored and the request is effectively being denied. Employer has the duty to request, clearly request from the applicant or employee any documentation that is needed, and there's a right there that the employer has. If somebody's asking for an accommodation due to their medical condition, the employer is entitled to some medical documentation to support that request. Treating physician or treating a mental health care professional. I'm treating this employee for Tourette syndrome. These are the conditions. Or again, if you don't want to disclose, there doesn't need to be a disclosure as to what the disability is. But these are the symptoms that are giving this individual a problem to get the job done. Here is a proposed accommodation modifying the work schedule in some way or form to allow the person to get the job done. That medical information should be made available to the employer. And sometimes we have to dismiss cases here at the division because the employee refuses to turn that information over. And it may be that they don't want to disclose what their diagnosis is. So I'm hopeful that in programs such as this, we can educate people that that may not be necessary in some circumstances, and that they can keep their situation confidential, but still have the rights to accommodation attached when they need it in order to keep their job. There's also an obligation on the employer to maintain the confidentiality of the medical information. It needs to be kept separate and apart from a personnel file. There's deference given to the employer to select which reasonable accommodation will be provided, so long as it's effective in meeting the need, and that's a big part of it. So when we're investigating these cases, we oftentimes have employers say, look, we offered this accommodation, it's effective in allowing the person to get the job done, but they didn't want to take it. They only wanted, what they were interested in. And in those cases, we may end up dismissing the case because the employer has met his or her obligation by offering an accommodation that's effective. And of course, the investigation is going to focus on whether or not it was effective, because that's part of meeting the obligation under the law. Excuse me. So our employee has duties too, right? We talked about this earlier. They have to make the disability and need for accommodation known to the employer, and has a right to request that accommodation anytime, regardless of whether or not the medical condition has changed. Employee has to cooperate with the employer. We get a lot of cases where the employee will just say, I want X, and there's no further interaction by the employee. And courts have said if the employee has demonstrated a withdrawal from the interactive process, they're not participating in a way that the law compels the employer to provide an accommodation. So there has to be a level of cooperation between the employee and the employer to provide the information as necessary, and of course understanding that information will be kept confidential. I want to talk a little bit about misconduct and direct threat. This can sometimes fall within the category of mental health impairments, and the human rights law does not require accommodations of behaviors that constitute a direct threat. What does that mean? Direct threat means a significant risk of substantial harm to the health or safety of the employees or others that cannot be eliminated or reduced by reasonable accommodation. This comes from the statute. So we're talking about a significant risk, we're talking about substantial harm, and we're talking about at least an exploration into whether or not some type of reasonable accommodation could have been afforded to eliminate the threat. This is all not to say that if someone comes into the workplace and does threaten somebody or does something to cause bodily harm to a fellow employee or a customer or whomever, that the employer cannot take legal corrective action, in terms of terminating that individual. What this provision of the law more so applies to is preventing employers from making assumptions about employees or prospective employees based upon some information they may have heard through the grapevine, or something has been disclosed somewhere where they find out that somebody is applying for a job and has Tourette, or somebody is working there and is bipolar or schizophrenic, and then assumes, based upon that information, that the person is going to do something bad, do something harmful, do something threatening, and therefore terminates them or denies them an opportunity. So that's really where the applicability of this comes into play. We don't allow employers to make assumptions based upon their understanding of a condition. It's based upon what's actually happening in the workforce, in the workplace, in terms of whether or not a direct threat has occurred. When we're determining whether or not direct threat exists, we're talking about individualized assessments. Again, not stereotyping or speculating or painting with a broad brush. This person has Tourette and therefore is going to be uttering foul language. I can't have that in my workplace. I'm not going to hire him or her. That is not something that's going to be tolerated by the law. We are looking not to make the employer Mr. or Ms. Doctor. We're looking at objective information to ascertain the nature and duration of the risk, the probability of injury, and again, whether reasonable accommodation can mitigate that risk. That covers it for employment. I think we're saving questions till the end. I want to touch upon housing. Housing is our employment. I said it was about 85%. Housing comes in at a solid number 2 in terms of allegations being made of discrimination against landlords or prospective landlords in terms of being denied housing opportunities on the basis of disability. Very broad coverage of housing under the human rights law. We cover both public and private housing. That includes rentals and co-ops and condos. Again, definition of disability. There's another federal law, Federal Fair Housing Act, that's substantially equivalent to the state human rights law. We have a contract with HUD, the Department of Housing and Urban Development, that enforces the Federal Fair Housing Act to investigate complaints under the Federal Fair Housing Act. But we, again, have a different definition of disability that does not include a substantial impairment of a major life activity. Again, we don't get hung up on how disabled are you. In terms of prohibited conduct, housing providers may not refuse to sell or rent housing on account of a disability, can't discriminate in the terms or conditions in the sale, lease, or ownership of an accommodation on account of somebody's disability. And we'll talk about that in a few moments. Can't use any type of advertising or, again, applications for housing that include inquiries similar to the ones we talked about in the employment context are prohibited under the New York State human rights law. Can't ask about past medical histories or medications taken, etc. Prohibited under the law. So there's a couple of obligations housing providers have to ensure that their premises are accessible to people with disabilities. Some of these apply more so for people with mobility impairments, people who use wheelchairs, and some of them apply to people who have mental health impairments in terms of using emotional support animals. So I want to talk about both of those. Reasonable modifications typically are structural in nature. It typically means, and I think I have examples here, widening doorways, adjusting kitchen or bath fixtures, installation of grab bars, installing ramps are typically examples of reasonable modifications that housing providers have to permit. Now, if you look at this section of the statute, it talks about at the expense of a person with a disability. So first question we ask here at the division is where is the modification taking place? If it's the interior of the individual's unit, okay, I want to modify my bathroom, my kitchen, my hallway, it's going to be at the expense of the individual with disability to make those modifications. So if somebody files a complaint here and says, I asked for permission, but my landlord said I have to pay for it, landlord's entitled to do that under the human rights law. If the complaint is, I asked for permission and was denied, and I was going to pay my contractor, and I was denied permission, then we have something under the law that could be unlawful. And it talks about existing premises. So oftentimes we'll have landlords say, no, I'm grandfathered in. My housing premises were built before your law, and we don't care about that. If your premises exists, it's therefore covered, and there's an obligation to provide reasonable modifications to allow full enjoyment of the premises. That's in the statute. So we're talking about ramps to the front door of the apartment building, not to the back where the garbage is stored, and where all the furnaces may be and what have you. It's talking about modifications that allow an individual with a disability full enjoyment of the premises. And we talked about these examples. There was an amendment in 2010. Earlier I said that if we ask where is the modification taking place, if it's taking place at a common area, the amendment now obligates the landlord to pay for the modification so long as it's reasonable. So installing a ramp or modifying an entrance that's commonly used by all the persons that live in that apartment building or in that complex, the landlord is going to be obligated to pay for that modification, again, so long as it's reasonable. We're not in the business of bankrupting landlords, and part of the investigation will look at, what are the resources this landlord has in order to pay for these modifications, in order to analyze whether or not it's reasonable or not. So we talked about structural modifications. There are also requirements to modify policies and procedures that housing providers may have. This area of installation of a ramp in a common area is now included in that provision. But here's an area where we get a lot of cases. It's an area where people with mental health impairments oftentimes rely upon a pet or an animal. There's a lot of medical literature that supports the fact that the relationship an individual with a mental health impairment has with taking care of a pet improves the quality of their life and diminishes the effects of depression or some type of psychiatric impairment. So waiving a no pet policy is a form of modifying a rule in order to allow an individual with a disability to continue to live in their apartment. You know, landlord says, I have a no pet policy. Person with a disability says, I'm suffering from depression. My doctor has recommended that I get a dog to take care of to improve upon my depression. Will you please waive that no pet policy to accommodate me, to allow me to continue to live here? Landlord, under the law, is obligated to waive that no pet policy to allow a person with a disability to live there with the emotional support animal. Parking is another area. We see a lot of cases, more so for people with mobility impairments, to the top of a waiting list to get a handicapped parking space, or indeed providing that individual with the handicapped parking space that's adjacent to where they live is another area we see cases, another area where the law, again, compels landlords to ensure that their premises are accessible and usable for people with disabilities so that they can use and enjoy their home. Attorney's fees are available. This can incentivize lawyers to take on cases with regard to housing discrimination. They'll get their fees paid, or can get their fees paid by respondents if they do indeed prevail. That's what I wanted to cover on housing. The last area I want to touch upon is places of public accommodation. This is an area of the law we don't see very many complaints, but certainly very important for people living with Tourette syndrome who may be denied access or otherwise treated differently, or denied the opportunity to participate in a function that's open to the public, or purchase or use goods and services that a place of public accommodation provides because of their Tourette syndrome. This is an area of important coverage under our law. And indeed, places of public accommodation are prohibited from discriminating against persons with disabilities, and are obligated to ensure that their goods and services and facilities are accessible to people with disabilities, again, by making reasonable accommodations. So there's an affirmative obligation that exists for employers, exists for housing providers, exists for places of public accommodation. It's not just you can't deny somebody because of their disability the opportunity for a job, the opportunity to gain housing, or to use goods or services. It's, we may have to make a modification here, a reasonable one, as to how we do business to ensure that our services, our goods are accessible to people with all sorts of disabilities. Again, a very generous coverage of public accommodation, hotels, motels, restaurants, diners, bars, retail stores, health clinics, and hospitals. You can see the list there. Government entities now are also included. There was an amendment recently to the state human rights law that also includes government entities in this area when they're operating as places that are open to the public. We do not, and again, this is with regard to places of public accommodation. We do not cover schools, colleges, universities. We do cover them as employers, okay? If there's a dormitory that the college is using that's denying housing opportunities for a student with a disability, we cover them as a housing provider. But we do not cover schools if the scenario is my school denied me this because of my disability. That is covered under the Americans with Disabilities Act. There are also coverages in other federal laws, including the Individuals with Disabilities Education Act, that speaks to the needs of students with special needs, that have coverage in a variety of areas in that way. So again, if we're talking as an employer, we cover schools, or if we're talking about a dormitory or provisions of housing, we cover them as a housing provider, but not as a place of public accommodation. You also see that religious institutions and distinctly private clubs are also exempt. We talked about the obligation to make reasonable modifications to policies, practices, or procedures to make goods and services accessible to people with disabilities. Examples, again, waiving a no pet policy, and I'm going to talk about this in a little more detail, for a person with a disability to use a guide, hearing, or service dog. Training staff, so important. We get so many complaints at our agency where somebody, was denied a service by the first person they saw, the maitre d' or the first salesperson's at the door, whomever it is, who doesn't know anything about the New York State human rights law and doesn't know anything about reasonable accommodation, and they deny service or deny service based upon disability, and now that owner is facing a complaint. A lot of times one of the remedies that we include in our judgment against those owners and operators of places of public accommodation is to do training to ensure that their staff understand, all of their staff understand what their obligations are under the law. Auxiliary aids and services is another area. We cover essentially what it is that places of public accommodation cannot deny an individual access to the place of public accommodation because of their refusal to provide an auxiliary aid or service. And what are we talking about? Typically in this area we're talking about provision of sign language interpreters for people with hearing impairments. We see a lot of these cases in the medical field where somebody who's deaf or hard of hearing has been asking or is asking their doctor to provide a sign language interpreter so that they can communicate, and the doctor refuses to provide that and essentially denies services because of a disability. So that's an area we see some cases. Providing materials in alternative format for people with visual impairments is another area. And again, acquisition of modification of equipment or devices. Again, all of these things are designed to change the way in which something is presented or provided or done, including a sign language interpreter so that people with disabilities can participate equally in the services that are provided by the place of public accommodation with people without disabilities. That's what it comes down to. Architectural barriers is another area. Places of public accommodation have to remove architectural barriers where it's readily achievable to do so to make their premises accessible to persons with disabilities. Readily achievable means without easily accomplishable and without much difficulty or expense. Again, the analysis is what is the cost of removing this architectural barrier versus what are the resources of this particular business to do that. And again, examples could include installation of a ramp, widening a doorway or checkout aisles, lowering service counters to make them accessible, curb cuts. These all come up in the area of people with mobility impairments, typically. Just to cover guide, hearing, service dogs a little bit more in this area, we had an amendment in 2014 to the law, which essentially what we're looking at is is the dog under the New York State human rights law? We're talking about a dog that's been professionally trained. So if somebody's been denied, somebody goes into a restaurant with their guide, hearing, or service dog, and they've been denied the opportunity to go into that restaurant. One of the first questions our investigators will ask the complainant is, has the dog been professionally trained? If that's the case, the dog goes where the person goes. Person wants to go in a restaurant, any place that's open to the public, dog goes where they go. Same goes for employers, and the same goes for housing providers. We're talking about dogs. We're talking about guide, hearing, or service dogs. Guide dogs being made available for people with seeing impairments, hearing dogs for people with hearing impairments, and service dogs. There are a wide variety that service dogs provide for people with a wide variety of disabilities. People with hypertension, seizure disorder, autism. There's a lot of medical literature out there, and there are a lot of organizations, bona fide organizations that train dogs that provide services to individuals with those types of disabilities to improve the quality of those individuals' lives. And again, if that dog has been professionally trained, that dog is going to go where the person goes. No reasonable accommodation analysis required. If the dog hasn't been professionally trained, and we're talking about a place of public accommodation, essentially what the law has done is it's adopted the provisions from the Americans with Disabilities Act, which talks about modifying no pet policies to allow for the use of a service animal by a person with a disability. So what does that all mean? Well, The ADA defines service animal as a dog, okay, that's individually trained to do or work or perform tasks for a person with a disability, or, believe it or not, a miniature horse. Miniature horses are also covered explicitly in this area. I've been practicing law, civil rights work for people with disabilities for 20 years. I never was quite so sure how to answer the question about miniature horses, but I did recently find out that the issue there for miniature horses is that they have a longer lifespan than dogs. So people who use miniature horses as a service animal do not have to undergo the training component, which is oh so important for somebody who uses a guide dog every 7 or 9 or 11 years, having to retrain that dog to essentially protect one's life when you're talking about a guide dog for somebody with a visual impairment, in terms of crossing streets and navigating public transportation, etc. But miniature horses are also trained to do these things, and while I've never seen one, they have a longer lifespan, and that's why they're covered. So there's a big takeaway from tonight's presentation. You can talk about service miniature horses. There you have it. And we covered this, no cats, ferrets, or monkeys, or snakes. And also, when we're talking about places of public accommodation, we are talking about service animals, but not those whose sole function is to provide comfort or emotional support. Okay, that does not apply in housing cases. In housing cases, whether it's a dog or not, and if it provides emotional support to that individual in housing, that's going to be considered a reasonable accommodation. Not so under the ADA. We're talking about we're talking about service animals, which are not those that provide emotional support, but are typically of the guide dog type, the hearing dog type, or the service dog type. Inquiries. So owners of places of public accommodation are prohibited from inquiring. The only two inquiries they can make are, is this a service animal? Is it required because of the disability, and what work what service is the animal going to provide to the individual with disability? I oftentimes get asked, can we ask for papers? Can we ask for tags? Some type of supporting documentation? And the answer is no, you cannot. You cannot do it under the Americans with Disabilities Act, and you cannot do it under the New York State Human Rights Law. We can do it as a law enforcement agency. If somebody's been denied the opportunity to enter a place of public accommodation because they went in with a service dog, we can say we'd like some medical documentation that supports your need for the dog. Owners of places of public accommodation cannot. So that's something that we oftentimes run into. Can't charge any fees, okay? Owners of public accommodations can't say we're going to charge you a fee to come in order to address any issues with the service animal. And I think that covers it for service animals. Again, I'm happy to answer any questions in this area that may come up. Just to wrap it up, enforcement. So if you think you've been discriminated against, you can download a complaint form. The website is there. We have complaint forms available in alternative format. I am the agency's ADA coordinator. If you need something provided alternatively, you can contact me. You can also contact any of your nearest DHR regional offices, which are all listed on that website, to ask for a complaint form, or again to file a complaint in person. All complaints must be notarized. There's no fee to file a complaint. You don't need a lawyer to file a complaint. The only thing that we require is that the complaint be notarized. That's a big distinction between our agency and state Supreme Court. You can go to state Supreme Court with a New York State Human Rights Law complaint, but you're going to have to pay a filing fee. You should probably have a lawyer. We are offered as an alternative to that in terms of also enforcing the human rights law. The complaints have to be filed within 1 year of the alleged discriminatory conduct. You have up to 3 years to go into state court, but you can't do both. Okay, you cannot do both. You have to, if you're outside of the year, obviously you'll go to state Supreme Court. If you're inside of the year, you can't file with us and file with state Supreme Court. You can't have two bites at the apple. Remedies we talked about earlier a little bit. Respondent, cease and desist from whatever the discriminatory conduct is. Take affirmative action. Hire the individual, reinstate that individual, or promote that individual. Back pay. All of that compensation is available under the New York State human rights law. Offering whatever the accommodations were unsegregated. The law is not designed to segregate people with disabilities. It's designed to be inclusive, to integrate them into employment, housing, places that are open to the public, and again, awarding of compensatory damages to any person who's been aggrieved by the discrimination. There is my contact information. I will leave that up, and that concludes my presentation. I think we have some time here for some questions.
Thank you, John. That was a wonderful presentation, and this topic is very important as individuals with Tourette and tic disorders, as they're seeking employment or housing, and just understanding their rights and the rights of the employers and as a tenant, and what accommodations are available to them. So we've, during the presentation, we've had a few questions come in, so I'll start with those. What types of accommodations, just in general, should employers consider for employees with Tourette syndrome?
So, typically with Tourette syndrome, it depends. If it's, I know there's a small percentage that manifest the tics and the different things. It may be that if there's some type of triggering mechanism that causes a problem or causes, the utterances that are associated with Tourette syndrome, to look and see what are those triggering mechanisms. Is there a way to diminish the likelihood of those triggering mechanisms from taking place? Is there an opportunity for the person to work in an area, again, qualified for the essential functions of the job where those mechanisms may not be triggered? If they're taking medications and the medications affect them in a certain way, modifying their work schedule to allow for them to take those medications and continue to do their job. It can also mean if they need to take some time or leave from work in order to get treatment, that also, if there's a reasonable amount of leave time the individual needs to get treatment, is another area of accommodation an employer can provide. Again, accommodation being designed to allow that individual to keep their job, to modify in some way, shape, or form how the job gets done, and keep that individual with a disability gainfully employed.
Thank you, John. So we have a question here. I have a situation where the employer accepted my medical documentation in returning to work and had me go through an accommodation process, which resulted in a confusing determination letter that essentially ended up preventing my return to work. It's been a confusing process with no transparency. If they accepted my medical documentation, can they make me go through the process again in a further attempt to have me receive a fitness for duty exam? It feels like I'm being prevented from returning to work based on my disability by HR staff who are making their own determinations about my fitness to return to work. What should I do?
I would encourage you to file a complaint with our agency on that. If you're being denied an opportunity to return to work, the medical documentation you provided states that you are fit and able to return to work and do the functions of the job, or that you're fit and able to do the functions of the job with certain accommodations. If that employer is denying you that opportunity, denying you those accommodations that would allow you to get back to work, I would encourage you to file a complaint with our agency as soon as possible so that we can investigate that matter for you.
Thanks. So here's another question that came up. Can someone with loud vocal tics be asked to leave a place of public accommodation, such as a restaurant? Does it matter if it's a noisy diner versus a movie theater where quiet is expected?
So if the person has loud vocal tics, and if somebody comes, an owner or somebody who works for the public accommodation wants to remove them, the person can disclose the fact that they have Tourette syndrome, or not even say it's Tourette. This is due to a disability or an impairment or a condition that I have, and I'm asking that I be allowed to stay here in order to accommodate my disability. If that accommodation is not creating an undue hardship on the owner of that public accommodation. So let's say it's a diner or a restaurant or where there is ambient noise. Can we maybe put that person in an area where, and again, not completely segregated, but maybe an area where there's less less noise going on. What needs to be looked at is, can this person be accommodated to keep them as a participant or as a user of that good and service with their disability. Now, if we're talking about a scenario where it's very quiet, it's a theater or something along that line, a respondent may have an undue hardship argument there, or the owner of the public accommodation may say this was creating such a nuisance or such a problem that it fundamentally altered the way this performance was being done, or altered the way in which this play was being put on or this movie was being put on. That owner of that public accommodation, the burden is on that owner to demonstrate that. So if you think you were wrongfully put out of a place or denied the opportunity to go to a show or see a play or have a meal somewhere, again, I would encourage you to file a complaint, because that burden is on the owner to show that this behavior really constituted an undue hardship. It really constituted a fundamental alteration of what the service was that I was trying to provide, and here are the reasons why. Now, they may be able to do that. But if not, they are prohibited by law from denying you the opportunity to participate in that event that's open to the public because of the fact that you have Tourette or because of these tics or utterances that you're having.
Thank you for that explanation. I think it's a very common occurrence or experience, for the Tourette community, and so thank you. So we have another question. We'll probably take just a couple more. Living in Iowa, I presume the protection is only through the ADA. What does a person have to disclose to an employer to be covered? Do they just need a diagnosis, documented disability, or specific disabilities?
So I would, whomever is asking the question from Iowa, I would first encourage you to do a little research on your own to see if Iowa has a state human rights law. And if it does have a state human rights law, what is the definition of disability? It may be similar to the New York State human rights law definition. If there is no Iowa state human rights law or nothing comparable, the answer to your question is yes. The Americans with Disabilities Act would provide protections for an individual. And under the Americans with Disabilities Act, the impairment needs to be substantial and affect a major life activity. So whatever medical documentation you're providing is going to have to emphasize the fact that the condition substantially limits a major life activity, and working is considered as a major life activity. And so it would have to be a little bit more substantive in that area if there's not a comparable state human rights law that has a definition that's comparable to the New York State human rights law one. But again, I wouldn't foreclose. Tourette syndrome, I'm confident in saying is going to be covered as a disability under the Americans with Disabilities Act as a substantial limitation of a number of major life activities. So I would say, if you provide your employer with medical documentation that indicates these are your symptoms or does disclose your diagnoses, and your employer continues to take adverse action against you, or it's a prospective employer and they're denying you the employment opportunity, I would get that complaint filed with the EEOC, the Equal Employment Opportunity Commission. They enforce the Americans with Disabilities Act, and you have to go to them first. You can't just run into federal court with a complaint. The ADA requires you to go to EEOC first and file a complaint there.
Thank you. So this is on a similar note, and this person is from Puerto Rico. So the laws may not be applied the same way. This person's question is, do I need medical treatment evidence to have the accommodations, or is enough with the diagnostic of the neurologist? I had a situation in which they asked me to bring medical treatment, like referring to pills and stuff, but I only use the psychologist in medical treatment.
I mean, in my estimation, that should be sufficient. What you want to be able to do is show the employer, okay, here are the symptoms caused by my condition that cause me a problem to do my job. This is the accommodation that I think is going to remove those obstacles or remove those impediments that are caused by my disability. And my doctor agrees with this, or my doctor is the one who's prescribing this, or my doctor is the one who's recommending, a modified work schedule, or recommending some type of a treatment plan for my condition that may require some leave time, etc. So the dots that we're looking to connect there is medical documentation that supports the fact that you're covered as a person with a disability, that disability that is causing some type of a barrier or an impediment for you to get your job done as your job currently exists, and that there's some type of an accommodation that can be provided to you that removes that impediment. That's reasonable, and those dots are connected and supported by medical documentation. That should be sufficient for the employer. And again, if you're getting a denial, use the Equal Employment Opportunities Commission to file a complaint.
Thanks, John. And I think that's all the time that we have for today. And so once you leave the webinar, you'll receive a survey on the presentation, and we'd really appreciate it if you would complete that and provide your feedback. You'll also receive a follow-up email within 24 to 48 hours with a link to review a recording of today's webinar. Additionally, the webinar will be posted on the Tourette Association YouTube channel for those who are unable to participate today. As always, we encourage you to reach out to us on social media about this webinar or other ideas and suggestions that you have. And again, we have a full-time information referral staff who can answer your questions, as well as by emailing support@tourette.org or calling us at 1-8884, the number 4, Tourette, Tourette. Again, thank you so much to John for a great presentation, and on behalf of the Tourette Association, thank you again for joining us and taking the time to view our presentation.
Yeah, thank you very much again for the opportunity. Very much appreciate it.
Thank you, John. Thank you.
Okay, thanks everybody. Have a good night.
Good night.